Hello, everyone. Thank you for tuning in today. I'm just getting set up on Instagram as well. I'm on Facebook. Awesome. So thank you guys for tuning in today. I'm going to be discussing the 2018 changes to the Georgia child support laws that just took place on July 1st. Everyone in Atlanta and in the state of Georgia has been hyping up this hands-free law that took effect this week, as if that's the only law. We have lots of new laws that came into place this week, and the one I'm going to be discussing today is the changes that took place with the child support statute here in Georgia. Can you guys hear me? Somebody's saying there's no volume. Somebody confirm. On Facebook, confirm. I know Instagram, I think you guys can hear me. I actually hear myself from the other room, so I think there is volume. So Shantaria, make sure you check your volume. Okay, thank you, Natalie. Hey, Natalie. Okay, so I'm going to be talking about the child support changes. Child support laws don't change all the time. I was actually surprised that we had a change this year because we just had some pretty substantial changes last year in 2017, which I have a video on the Facebook page. If you go and look, it's called the 2017 changes to the child support laws. The last major change we had to child support laws were in 2007. So here we are 2 years back to back with substantial changes. And when I saw the changes for this year, I was like, oh my God, these are game changers. So I am looking forward to discussing those with you today. Before I get into that, just want to introduce myself to you. For those who don't know me, I am attorney Joy Farrell, and I'm the managing attorney here at the Farrell firm, where our practice focuses on family law and personal injury. Our family law practice is comprised of child custody, child support, divorce cases, and our injury practice is based on auto injury, pedestrian injury, slip and fall, etc. We are located right off 285, Lawrenceville Highway in Tucker. So you can pretty much get to us from anywhere in the city within 30 minutes. You can find us at atlantacustodylawyers.com. And over on our website, you can make an appointment to meet with myself or someone in the office. You can learn about me and the team here. And you can also find all the previous videos that I've done pertaining to family law matters. We've done about 30 other videos, so you can find those on our website. So I'm getting ready to go into the content. So I'm going to ask all of you who are tuned in, hey, Instagram, I'm not looking your way because my main screen is on Facebook, but I see you over there. So hi, everybody. Go ahead and share this live post with your friends because this is definitely information that you want to be able to be aware of if you have children in child support orders. So before I get going, I want to give you the legal disclaimer. So by tuning in today, you acknowledge that the information given on this broadcast is for informational purposes only. And by tuning in, you and I are not creating an attorney-client relationship. All the information that I am giving today is based on the laws of Georgia. So if you so happen to live in another state, this information does not apply to you, and you should reach out to get information from a family law attorney in your state. Okay? So let's get going on these changes. So if you have any questions throughout the broadcast, feel free to type them. Instagram, you do the same, type them, and I will get to them at the end of the broadcast in the order that they were received. And we're going to be discussing 4 primary changes to the current child support laws. The first one is going to be the requirement for multiple child support worksheets if you have multiple children. The second discussion is going to be the ability to pay your child support. The third topic is going to be imputing income for a calculation of child support. And the fourth one is going to be incarcerated income determination. So if someone is incarcerated, what changes are taking place with determining their income for child support purposes. So going into the first one I said we're going to discuss, which is going to be the worksheets for multiple children. So this is actually one of the changes that we saw take place last year in 2017, and it's now being amended. So last year, the law changed to add in the language that the courts were required, i.e. made it mandatory to use multiple child support worksheets if there were multiple children between the same parents. This was actually very beneficial to the person who was paying child support because it essentially helped them to avoid having to file a modification of child support once one of their children became 18 years or older. As of July 1st this year, instead of it being mandatory, it is now permissive and it also limits the circumstances in which you can request the court to do this. So there's a 2-year limit on the anticipated change. So therefore, if you have 3 children who are 12, 14, and 16, and the 16-year-old, obviously within 2 years will be 18, the court is then permitted to allow 2 worksheets. And in this scenario, there'll be 1 worksheet for the 12 and 14-year-old, and then another worksheet for the 16-year-old, so that when the 16-year-old turns 18, the child support technically automatically decreases to the amount in the worksheet for the other 2 children, which were the 12 and the 14-year-old. The ability to use the multiple worksheet is now in the discretion of the court, and it in no way stops a party from seeking a modification of the child support as long as they meet the statutory provisions. The key here with this change is if you are the person who is required to pay the child support, you need to make sure that you're requesting the judge to take multiple worksheets into consideration so that you don't have to spend another couple of $1,000s going back to court to modify child support when it was already foreseen that within 2 years, one of your children would age out of child support. Okay? So that's not a big deal. We're about to get into the ones that actually make a big deal. The ability to pay. So prior to July 1st, 2018, courts were not really concerned with the non-custodial parent's ability to pay. A lot of people who are the payers of the child support will come to me and say, well, what about my other bills? I have to live. I got to be able to provide for my other children, etc. And I would have to let them know that those factors were not really considered. It was always kind of like, the court doesn't really care about your other expenses. You have to take care of your children regardless. Now, however, language in the new law as of this week is there to ensure that the non-custodial parent has the ability to pay the amount of child support awarded. So the court has to take the ability to pay into consideration. So what the statute says is that the judge can look at how much money the person makes, other evidence of their ability to pay, and they should also consider that person's basic needs for what they have going on in their own life. And this is just a huge twist in the previous law, and it's going to be very important that you have an attorney to be able to make this argument before the court. There's lots of scenarios where we have child support orders that are just not affordable for the non-custodial parent to pay. And so if that is going to be your scenario, you want to make sure you have a lawyer there advocating under this new law saying that, hey, I can't afford $650 per month because I have A, B, C, and D. Now, if you're going to be the person receiving the child support, you also want to make sure you have a lawyer to make the other argument. Because while it is understandable that you don't have the ability to pay it, the other side wants to look at why don't you have the ability to pay it? Because if you have a $800 car note and you're taking trips and everything else, then that's not an ability to pay. That's living lavishly and kind of skating on your financial responsibilities as a parent. So lawyers are going to be able to argue this both ways. So it's going to be very important to have a lawyer, and we'll see case law develop on this as cases go through the courts. So just make sure you're aware of that. And if you're struggling to pay your child support, then you may want to consider a modification at this point. The next one is even a bigger change for me. When I read this, I almost choked, for real. I couldn't believe it, because this change, in my opinion, will have the greatest impact on the previous law. So previously, as in since 2007, so for the last decade, if someone did not have a job or they didn't work enough hours, at a minimum, the court was required to impute/apply income to that person in the amount of $1,261 per month, which statutorily is calculated as 40 hours per week at minimum wage. And so basically, it was believed that every able-bodied adult should be able to at least earn the $1,200 per month. Now, as of July 1st, 2018, the law has removed this mandatory imputation of minimum wage income. Gross income for the current year can be imputed, but the court can look at other things when imputing income. So we're getting rid of the minimum wage calculation. So there's no minimum amount going into the worksheet. When imputing income now, based on the new law, the court should take into account specific circumstances of the parent's assets, their residence, employment, earnings history, job skills, educational attainment, literacy, age, health, criminal record, any employment barriers, their record of seeking work, the local job market, the availability of employers that are willing to hire the parent, previous earning history, and the statute says any other relevant background factors to the case. So when we start looking at imputing income, so sometimes we have people who may have records and they can't get a job, or nobody will hire them for whatever reason. Those people are now have a level of protection going in, and they're not going to be imputed to a income that is actually more than what they make, which therefore prevents a child support order from being entered that's technically more than what they can pay. So when we're looking at this imputation of income, it's going to be a lot of argument here by lawyers. So again, it's going to be very important to lawyer up in these scenarios if you're somebody or against somebody who does not have a regular job, W-2 paying job, if they're not working full time, because now we don't have a minimum standard of what we're imputing income. It can literally be anything. It could be $500 a month. It could be $10,000 per month. We don't know. And this is opening up the floodgates, but it's going to be very helpful for those people who truly cannot find employment or cannot keep employment or who are sick. Sometimes we have people who are very ill and they're on disability. They can't work and they're still getting put in at the 1261. So this is a different scenario now. If you can't work, then you're not going to be put in the worksheet at that amount. Okay, so the last thing we are going to discuss is incarcerated income determination. Previously, if a parent became incarcerated, their wages pre-incarceration could be used to determine child support. So if you were making $40,000 a year before you were arrested, even though you were in jail, your child support payments would be calculated on the $40,000 per year, which is insane because we know you're in jail and we know you're not working and we know you can't really pay child support technically. So anyway, the new law says that if a parent is incarcerated, the court shall not assume an ability for earning capacity based upon pre-incarceration wages or other employment-related income. But income may be imputed based upon the actual income and assets available to the incarcerated parent. So for some people, that's nothing, that's zero. They don't have any assets in jail. But for other people, who may be in jail, they actually do still have assets. Just because they're in jail doesn't mean they lost any of their savings or any of their investments or whatever. So in those scenarios, people who actually have assets, we can still get that child support based on what they have. If they don't have assets, then it looks like we're not really going to be able to get any money from an incarcerated parent. So one of the other things that's changing about this statute is that an incarcerated parent shall not be deemed willfully or voluntarily unemployed if they are incarcerated. Previously, under the statute, prior to changing, you would make the argument for imputing income that someone is voluntarily or willfully unemployed by their own doing. And the argument that lawyers would make is, hey, you broke the law, you got arrested, so you voluntarily got locked up, meaning you voluntarily got fired from your job, and therefore income should go in at your previous earning capacity. So all that's out the window now. Incarcerated parents are here actually going to have more protection. So these are the 4 major changes that I thought that you needed to know. Each of these are definitely going to be game changers, and the law is becoming more obligor friendly. So the person who's paying child support is actually getting some breaks here. And that's what people kind of have been demanding. So depending on which side of the case you're on, you need to make sure you definitely hire a lawyer as we go through these new changes in the statute. And ideally, if you can, you should hire someone here at the Farrell firm. So I'm going to go through and answer any questions if you have any. I'm going to start with the Instagram side, only because I've not been looking at you guys. So I'm going to pick up my phone here. Okay, the essence says, my child's father, child support payments were coming out of his check. Now it has completely stopped. Okay, in that scenario, he may have switched jobs, essence. That's going to be my assumption, because the employer is under the obligation, if there's an income deduction order, and that's what you have when your child support payments are coming automatically out of your paycheck. It means there's an IDO. It's an income deduction order where the employer is required to automatically take the payments out of the paycheck and send it to the other person. So if those payments have stopped, it is probably because he lost employment. So you should probably, I would contact the employer first to make sure they have a copy of that income deduction order. And if they say he doesn't work there, then you need to try to find out where he works. It's really his obligation to update the new employer with that information, but find out where he works, send it to them. If he doesn't give you that information, just because he's not getting it taken out of his check doesn't excuse him from his responsibility. So every payment that you have missed, he is still going to be responsible for it. And I would give it, say, 2 months. And if he's not making himself current, then you should consider filing a contempt action against him. Okay, so now I'm going to hop over here to Facebook. Okay. Okay. I see a lot of comments. I'm just looking for questions, scrolling. Yeah. Okay, so here's a question from Ashley. She says, what if non-custodial parents work under the table so they don't have to pay and they have not filed taxes in years? Actually, this is such a common thing. Like, at least 1 in 3 cases is this exact scenario. So, and I don't want to give, too much away on this, because I don't know, some of my opponents may be watching this, but we have ways to kind of figure out how much money they have, or what we should calculate that income as. And so it's not the end of the world that they're working under the table. And those people actually make a lot more money than others because they have the benefit of not paying taxes. So there's definitely ways around that, and you can still pursue child support despite them hiding money. Hey, Candace, I see your your comments. Thank you for your support. Oh, you guys are so sweet. Such supportive comments. Okay, so here's one from Sondra. What if you're a stay-at-home mom who hasn't worked in 8 years and now having a hard time getting hired? Okay, Sondra, so this new law would be great for you. Last week, they would have put you in minimum at $1,261.50 because they believe that you should be able to earn minimum wage full-time at a minimum basis. Now, under the new law, as long as you have proof that you've been applying for jobs and trying to get a job and you're not, then we may be able to put you in closer to that zero amount. But I would definitely encourage you to keep a record of your applications, any interviews you're going on, anything you're trying to do to make yourself employable. And, don't overlook certain jobs. There's plenty of jobs out here that we may or may not want to do. But if you really need income, you definitely need to explore all avenues there. Jaquisha says, will these changes apply to new applicants only or to individuals who are modifying as well? Good question, Jaquisha. This is now the law. So if you are in the middle of a case right now, this law applies, whether it's a modification or an initial action. Is Georgia State a timeshare with the child also used to determine child support? No. I know some states, like I was previously barred in Michigan, and they were a timeshare kind of state. In Georgia, we do have provisions on our worksheet where we can give credit for parenting time, but you don't get, there's no formula for how many days you're spending with the child that determines how much your child support obligation is. Okay, Heather, what if they could get a better job but just don't and have decided to only pay you a certain amount on their own standards? Heather, so that's, again, under this new law, when you say they can get a better job but they don't, how do we make that argument? How do we know they can get a better job? Are they certified in something? Do they have a degree? Do they have training in mechanical work, but they're choosing to work at McDonald's? I mean, we have to be able to make that argument under the new law, and that's why lawyers are going to be crucial. And just as a FYI, he's deciding to pay you whatever he wants because you haven't put him on a child support order. So if you want a consistent amount every month, you got to take him to court. You guys can't just make these random side agreements and expect them to be enforceable because they're not. Only a court order is enforceable. Now, if you're somebody that's taking care of your child and you don't need a court order to tell you to take care of your child, that is great. I commend you. Continue to do it. But if you're in a scenario where someone doesn't pay their child support consistently or they don't give you enough, then you need to go through the courts. What if you're paying child support for a child that is not biologically yours? Kevin, you should not be doing that. Why would you be doing that? If you're paying child support for a child that's not biologically yours, unless you were married to the mother, which makes them legally yours because you were married when she had the child. That's a whole different scenario. But anyway, we can delegitimate or you need to file a modification. If you know this child is not yours, you should not be paying child support. What about a parent that's paying child support with multiple kids? What do you mean, Mercedes? If you're talking about now the ability to pay, we will be looking at the other expenses, including those previous child support orders. But the worksheet already has a part in it where we put in previous child support orders. So that's not really changing unless all those child support orders are making it very difficult to pay. And in that scenario, I guess under the new law, we can consider it. This is new for me too. So I'm not sure how these things are going to weigh out in the courts, but that's most certainly an argument that can be made. Tommy says, do you guys help fathers who really can't afford an attorney? Tommy, we do not do pro bono work, but I do encourage you to contact your local legal aid office, or you can, as a service to the community, I'm doing these videos. So you can find them all on our page and you can get so much information for free on here. So I hope that is able to give you some guidance and some help. Erica, Can you repeat the changes? Erica, as soon as I get off of this broadcast, this is going to be on our Facebook page. So you can go back and access it and listen to the beginning. Crystal, we're in the middle of our divorce. My husband has moved out of the state to Wisconsin a month prior to our final hearing, which is this month. He quit his job here and relocated with no job. How will this affect how much I will qualify to get for our 2 children? I believe he is trying to stop work to prevent having to pay child support. A lot of people do that, actually. And what we do in that argument is we base it on earning history. So you just had a job. So I would calculate it off of that. And that's what your lawyer should be doing. Hopefully you have a lawyer. If you don't have a lawyer, you should not be going into a final hearing pertaining custody and child support without counsel. Jamie says, how much do you charge? Our retainers start around $4,000 and they go up from there. You can get a consult with our office for $150. Once you come in and talk to one of the attorneys, we kind of make an assessment of your case, what you need, and all of that. We do require our money up front, so we don't deduct from anything on the back end. Okay. If my child's father is married, would his wife at all be brought into the umbrella for paying child support? No. A step parent has no obligation to pay child support. However, I do feel like under this new provision of the ability to pay, you having a second income in your household affects that argument. You know, you say, oh, I have all these bills. Well, you also have a wife that works. So you should be able to pay this child support. Let me hop over here to Instagram real quick and see if I missed any questions. No, okay, I did not. Is there a difference? This is from Stephanie. Is there a difference between court-ordered child support and dfacs ordered child support? Nope, they're both orders of the court. Department of Family and Child Services is a state agency, so they bring it through the state, but they still go through the Superior Court just like I would as a private attorney. So they're both court orders. It's no different, Brian, if mom signed a paper saying she wants nothing from you and it's not notarized, can I help in court? So we get this all the time. People always say, like, I don't need you to help me take care of my child, or I don't want your money. Especially if our dads are primary parents. God, they don't want any money from a woman. But listen, child support is not your right. It's the right of your child. So you don't have the ability to waive that. So even though you wrote it out on a sheet of paper, and even if it were notarized, it doesn't hold up in court because it's not your right to waive. It's your child's right to have financial support from the other parent. I'm going to just show this one because she says she loves my hair change. Thank you, girl. I appreciate that. Okay. So Elyse says, I just requested a modification. I'm currently unemployed. Will I be turned down for the increase? Requesting a modification through the state is iffy because it could increase or decrease. It just depends. So that's a risk you're taking. You may want to run some numbers before you proceed with that action, and you may need to dismiss it. Just because you're currently unemployed at the time of your case, that the court doesn't really care about your current employment status. We're mainly concerned with what is your ability to earn income, because you cannot have a job today but have a job next week. So your current status, you're going to have more arguments that, like the lady earlier was saying, she's been at home for 8 years. She hasn't been able to find a job. This isn't something new. So it's different. Marlena says, what if he's on the run from the law? He has money, but everything is in his mom's name, but he has a lawyer for his cases that he's on the run for. So if he's on the run from the law, I'm thinking he's running from something criminal. So hopefully they catch him. If he's putting money in his mom's account, it's going to be hard to subpoena her records if she's not a part of the case. So we would just have to kind of do some digging there. And Cheryl is in my office, and she's responding to a comment earlier. So she's basically saying if somebody's working under the table, you definitely need to hire a private attorney and don't go through the child support office, because all they're going to do is check Department of Labor. So when they run Department of Labor and somebody's not coming up, meaning they're not a W-2 employee, they're going to put them in as having no income because they didn't come up on the Department of Labor. But there's plenty of 1099 employees or people who work under the table who have plenty of money that's not going to be in the system on Department of Labor. So if, don't go through the state if you're going to need to really find some money. Maurice says, what if the mother doesn't want to work and place me on child support? So Maurice, that's definitely something you probably should seek a lawyer about. Like wanting to work. Why? Why doesn't she want to work? You can't just not work and have kids. You can't just live off of somebody's child support. Although a lot of people attempt to do that, you need to have somebody go in and advocate for you and demand that she helps to take care of her portion of these children's expenses. She can't just live off of your payments. Mercedes says, what if you're working but not making any money and still have to take care for the kids? Well, we have a provision in the worksheet that we put in qualified children that you're taking care of. But if your money is that tight, then that's under this new law, the ability to pay is something we're going to be highly litigating now. If both parents see the kids 50-50, is there still child support? Yes, this is a current misperception that if you have 50-50 custody, you automatically don't have child support. That's not the case. It depends on the money. So if dad makes $120,000 and mom makes $30,000 and they have 50-50 custody, well, dad's still going to have a child support obligation. But if they kind of make the same kind of money and then they have 50-50, that's going to probably wash the child support. But it's not a guarantee just because you have equal custody. Melissa says, what if the child is 22 and he still pays child support? If the child is 22 and he's still paying child support, my hope is that he's paying arrears, meaning back payments that he may have missed when the child was under 18. If the child is 22 and he hasn't filed an action with the court to terminate his child support, I have a lot of questions here as to why this is going on. That is 4 years past majority. And he needs to, if he doesn't owe back support, he needs to file something immediately to turn off that support. And to go ahead and answer the question that I know is coming, will he get the money back that he paid extra for the 4 years? No, he will not. It is a gift. Anything you give above and beyond is considered a gift. So it is your responsibility to stop those child support payments. Does child abandonment apply if you don't yet have an order in place? Yes, you can still take out a child abandonment warrant without a child support order in place. Typically, if you do that, once you go to the child support, once you go to the abandonment hearing, they're going to pretty much put you in line with the child support office to get an order in place. Okay, KT says, my original divorce decree was income deduction. For some reason, it stopped. Well, you need to find out why it stopped and get it reinstated, because everything that should have been paid is still due. So you may be accumulating arrears. So if it's your check that it was coming out of, you need to be writing manual checks or making transfers to the other parent of the child. If you are receiving the money, you need to be letting the employer know that the payment stopped, and you need to be asking the parent to make those payments. And if they don't make the payments that they owe, then you need to be filing a contempt action. Stephanie is basically saying, how does contempt proceedings work? Non-custodial is behind $7,000. He has ability to pay but chooses not to. So you definitely need to file a contempt, girl. Like $7,000. He has ability. Contempt is all about the ability to pay. If you have the ability to pay the money and you're not paying the money, then you can ask the court to lock him up, and he can make a purge payment of the full $7,000 or $2,000 or whatever. And it's if I'm representing dad, then I'm gonna say that's crazy. Like, don't you dare lock them up. That's insane. How is he supposed to make money if you lock him up? But if I'm representing mom, I'm saying lock them up. People come up with money real fast when they get locked up. So it just depends on who I represent. I don't favor men or women, but in this scenario, I would just file a contempt and ask that he be incarcerated. Okay. What if the children are in your custody for over 7 years and not getting support from the other? Is there a way to stop back child support? Okay. So if there is a custody order here, then I'm going to assume there's also a child support order. If you haven't been getting child support, then you need to file a contempt of that order. Now, this is a scenario where the other parent actually has custody on paper, but you now actually have the custody. You still need to file a modification with the courts because you can't, by agreement, modify custody or child support because the child support is going to continue to accrue. You're going to have to do an official switch of custody, official change of child support to avoid the arrears accumulating. Heather says he's supposed to be paying me a certain amount, but he doesn't. File contempt. That's the answer. Yeah, for one child, but he has other kids. Okay. So you can be able to go into that new statute, Mercedes. Okay. I need your lawyer. Give us a call. Our number is 678-973-2803, or you can find us at AtlantaCustodyLawyers.com. Everybody who's saying they need an appointment, I'm going to put the number up here. But AtlantaCustodyLawyers.com, you can find us right there. Royal says, why no one tries to help men? Royal, like I just said, 50% of our clients are men. We go hard for our fathers. We go hard for our mothers. We go hard for whoever hires us to represent them. You have to stand up for yourself. If you're over there being mistreated, but you're not seeking counsel or seeking representation or using the courts to your advantage, then you're not trying to help yourself. So if you want help, you can most certainly call our office and we will help you if you want to hire us to do that. But there's no need in sitting around being upset or feeling like you're being mistreated if you aren't taking the steps to do what you need to do for yourself. Shayla says, how do you enforce a monthly amount on arrears when child is 18? File a contempt, Shayla. Just because they're 18 doesn't erase the obligation. Shannon says, if I get paid more, does the non-custodial parent pay less? Technically, it goes into the worksheet. There's a formula, but the more money you make, the less they will have to pay, technically. The lease, what is the new law? Came in late. As soon as I finish, this is going to post to our page, so you guys go back and watch the beginning of the video. Okay, Vickie says, how do I proceed with receiving payments when I move to Georgia and the father lives in another state? He hasn't paid anything to my son in 13. My son is 13. Georgia does not have jurisdiction over the father because he does not live here. You're going to have to file an action in the state where he lives, and I would file a contempt there. Shayla says, and if the state states they cannot serve a non-custodial parent, if they will not answer the door for court, how can you get them to serve? So that's the most difficult part with going through the state is service. They'll just say we can't serve, end up dismissing your case. You're probably gonna have to hire private counsel because we will get them served. Again, I'm not gonna give away my secrets on here, but we'll get them served. Mrs. Stark says, I have a child support order for one child and currently filing for a divorce from my wife, whom I have 3 kids. With this new law, would it be beneficial to modify my pre-existing child support order? Income was based on ability to turn income for a stay-at-home dad. I would not modify that previous order because your child support is probably going to increase for that one child, which may not be worth it when you're looking at this new child support order coming in for 3 kids. But you will get credit for that. M. Joy says, child's father is currently in prison. Is child support still an option? Well, it is an option. I'm just going to call you Joy because that's my name and you just use your first initial. It is an option, but again, under the new law, how are we calculating this amount? Does he have money in the bank? Does he have assets to pay it? If he doesn't have it, don't waste your time. Don't waste your money. Wait till he gets out. But if he has some assets that he put away before he went in, then it may be worthwhile to pursue that. Okay. Royal says, y'all making it impossible for men who pay child support and still have no visitation right. Okay, Royal. I don't know who you're saying, y'all, or y'all just talking to the comments on here. But again, You don't have visitation rights, and you may want to go back and look at my video called What Unmarried Fathers Need to Know. You don't just get rights because you pay child support. You have to file a legitimation in the state of Georgia. If you had a baby outside of wedlock, you do not have any rights, okay? You have to file an action with the court. Just like if a mother wants child support, she has to file an action with the court. So both people have things to do. Women, you file for child support. Dads, you file for visitation. If you don't want visitation, you don't file. If you don't want child support, you don't file. But if you don't file, you need not complain. So if you want your rights, then you have to go through the courts and file the appropriate paperwork to be able to get those rights. Then you will have your visitation and custody rights. Kayla says, how does abandonment work? Basically, if you go more than 30 days without providing support for your child, somebody can go and take out a criminal warrant for abandonment. Courtney says, dang, I skipped you. I didn't see you, Courtney. Repost it. I'm scrolling. I'm doing the best I can. Repost it. I can't go back, though. Man says, does Georgia recognize both incomes for child support? Yes, they do. Mom and dad have both incomes are used to determine the support. Jerica says, I need help with my child support. My son is about to be 18 next year, and his dad won't pay nothing, and he has $2,000 in arrears. So you want to file contempt there, Jerica. Shoni says, what if the father just started receiving Social Security disability? Can the child receive any of that money? It depends, but most likely, yes. I think I already answered this question. You should not be paying child support for a 22-year-old unless you owe back child support. What happens if father's company keep denying child support to come out of his check? Well, based on the income deduction order, it says that the employer can become personally liable for that. So I don't think that's something they want to get into. So you might need to make some phone calls or come in or something. You need to make sure that's actually factually happened. Like, did they tell you that? Did they send you that in the email? Because if so, I would make them personally liable for the child support payments. And if anytime that payment is not coming out of the check, the person is still on the hook. So if I get my paycheck and I see my $600 for child support did not come out of the check, then I need to write a check to the other parent. And I need to do that for so long as it's not coming out of my check. Just because it's not coming out of your check does not give you a free pass at paying your child support. Is it possible to put the grandparents on child support? Why would grandparents be on child support? They don't have any obligation to a child that they didn't birth. Grandparents can put you on child support if they're taking care of your children, though. Shermain says, can you file a modification due to unemployment? I wouldn't, because you'll be employed by the time the modification goes through the court system. Does the non-custodial parent pay less if I get paid more than he does? He's a police and currently paying based off minimum wage from 2015. You should file a modification because I'm sure he's making more than minimum wage. And yes, the more money you make, the more money each person makes, it affects the other person's obligation. So, but that's no reason to make less money. It doesn't make that big of a difference. Tawana says, I believe only in certain cases. I'm currently working part-time from a disability. I don't disagree with helping with the outside child, but with me not having a full-time job, it's hard around here as we have children over here. But I do agree that the spouse could help. Okay, yes. If the father and mother live together, why is the father required to pay child support? Well, he's really not required to, and he should file a modification ASAP. Like, why would you be paying child support and you live there taking care of your kid every day? That doesn't make sense. Vickie says, does it matter if you no longer live in the state and the case is open in it? Jurisdiction for child support is going to be where the person is going to pay the child support lives. So if in your situation, you were talking about the father of the child, if he lives in Georgia or wherever, as long as the case is in his state, it's going to be fine. Doesn't matter where you go. Shone, I see your follow-ups about Social Security. We'll have to talk about that in the office. Lee says, can we switch from the state to a private attorney? Absolutely, you can. LaQuisha says, what happened if the child stops going to school and the mother never reported? The child goes to jail at 18 years of age. So LaQuisha, in this scenario, so when we stop child support, it's usually at 18, high school graduation, or anytime the child is emancipated. The child can be emancipated at 16 if he's living on his own and an adult. So in this scenario, I will most certainly say being in jail, he's now emancipated, and there should no longer be a child support obligation. So a modification needs to be done. Can you get VA and child support? Or do you have to choice on asking for someone? What is VA? You're talking about disability? It depends. But yes, you can get, sometimes depending on the type of disability, the child will automatically get a check anyway, and then that will be credited towards child support. Julie says, how she get the non-custodial parent served if they're unable to serve him? She filed in 2009, girl. That was like 10 years ago. Your child should be almost grown. You need to stop working with the state. You need to come hire somebody else. It's crazy. Zoe says, what if he just got custody of his son and it's just him because his wife is in prison? He lives with his mom and stopped paying a month ago. I'm assuming he got custody of the child you're not talking about. If he was paying support for the child he now has custody of, he doesn't have to pay child support. If he has another child that he has custody of and he's not paying support for your child, he's still on the hook for that, and you should go ahead and file a contempt on that. Love says, what if they owe like $5,000 based on child support worksheet but haven't filed taxes in like 8 years while ever get the funds? You should probably take it up through the contempt private side of the case, not through the state, because what you're waiting on is a tax garnishment. If they don't file taxes, you're never going to get it, and they probably never will for that purpose. So you probably want to pursue it in a private action and try to go the request incarceration route. That usually works. Rebecca says, what qualifies someone for child abandonment? Again, 30 days with no support of your child. Yaman, make sure you tune into the video. As soon as I get off, it's going to post on our page. You guys go back and watch the beginning. There's so many questions on here. I usually don't get this many. Okay. My dad is on Social Security in the backup from when I was 3 and I'm 25. I called to see if they will take his SSI for child support. They told me no, they will not take it. Yes. Okay. So I'm assuming your dad is tired of having to pay the support given that you're grown. He should probably be making those phone calls, not you. Ashley Roberts, how do I file the abandonment? Just go down to the courthouse and tell them you want to file for abandonment. This is a one-page sheet of paper. You fill it out. Kia says, what if I take care of my child, buying everything the child needs, but don't pay money, but don't put money in her hand? How does that work as far as getting the child legitimized without being put on child support? The mother okay with that agreement? I'm asking for my husband. Yeah, so don't put, buying stuff for the child is a gift. Okay, that's great. You should still pursue the legitimation. And if mom wants to agree that you basically keep doing what you're doing, we as lawyers have to word that the right way to meet statutorily. We can't say, oh, we're going to waive child support because you're buying new shoes and everything, because what if you stop? And then what recourse does she have? So we have to word it the right way. You guys can most certainly continue to do what you've been doing, but as lawyers, we have to put it in the paperwork the right way. So I would definitely still say pursue that legitimation action, and we can work out the logistics of how we get that order signed throughout the pendency of the case. Once a child is 18 and living on college campus, does the child support go to the child directly, or is it still due to the non-custodial parent? Girl, it's not due to nobody. Child support don't go in college. As soon as they graduate high school, that's it. It's over. Vickie, depends on where the dad lives. That's where you need to transfer the case to. I'm just scrolling. Me and my husband are in a custody battle with his son's mother. We went to court the first time. She wasn't allowing him to see his son on a court order visitation. Now, a year later, she still isn't letting him see his son. She lies and said that she moved, so he stopped coming because he didn't know the address. And now she's saying and telling everyone that he stopped seeing his child for a year. What can we do? I would continue to file contempt. When it comes to, just like I'm talking about incarceration for dads not paying child support, I talk incarceration for moms denying visitation. So you denied me 36 days of visitation. Some of these judges will put you right on in jail for 36 days. Any day denied, you can do jail time for that. It's serious. So he needs to, if he doesn't know where she lives, he needs to get a private investigator, find out where she lives, and demand his child. Larry says, what if you weren't making what you were? Then you may need to file a modification, but you want to run some numbers before you do that. Because if you're making a little bit less, it's not going to be worth it. But if you're making a lot less, it may be worth it to file a modification. Can you be placed on child support if both parents live in the same home, but one works out of town? I would say no, not if you're paying house bills. If y'all live together, you can't be on child support. Crystal says, what if someone is working on the table? We have ways to find out that income. Just don't go through the state. What if the kid has autism? How long will the father have to pay child support? Unfortunately, the law has not expanded on disabled children. The child support stops at 18 as well. Jaquisha says, do we represent clients all over the state of Georgia? We do Metro Atlanta. So all the, DeKalb, Gwinnett, Fulton, Cobb, Rockdale, Newton, all those, Metro Atlanta. Okay. I'm just scrolling, looking for the rest. What if you put on child support and the child's now 20 years old? That should not be possible. So call a lawyer. Nuki says, can you help the mother and then the father hire you too? No, we cannot. We can only help one. So the first one to hire us will be our client. Then the tree says, what if they're still in school? Only if they're in high school. Child support is still due as long as they're not over the age of 20. Okay. So guys, I still see your questions. I'm gonna, me and my staff are gonna get on here and start answering them by hand because I need to wrap up today. But just so you guys know, I am going to be live on Wednesday, this upcoming Wednesday, just for a Q&A. Like, I'm not going to be giving out information, but you can bring your questions here and then we'll just chat back and forth. And that'll be Wednesday night. So for all of you at work right now, it'll be like Wednesday evening. I'm thinking like 9:30-ish, somewhere around that time frame once I get my kids off the bed and everything. So I'll be available to go through and answer more of your questions. Me and my team, we will come through and start typing answers to some of these questions that I was unable to get to. I really appreciate all of you guys' support for tuning in today, and I hope this information was helpful to you. If you want to go ahead and schedule a consultation to come into our office, the number is 678-973-2803. You can go to our website, atlantacustodylawyers.com. Or ferrellfirm.com, and you can book an appointment online, or you can find access to all of these videos as well. And while I'm here, I just want you guys to be aware that we also have a podcast where we just discuss various topics and kind of give a little advice there. It's actually pretty funny. So you can find it on iTunes, and Android has it as well, or you can go to feralfirmpodcast.com and check out our episodes. We have about 9 or 10 already uploaded. So make sure you subscribe to our channel. Follow us on all social media platforms, YouTube, Instagram, and Facebook, and we will stay in touch. Facebook, we're very responsive. If you have a question, go ahead and send it. We're not going to give you a whole synopsis, so we'll answer questions, but if it sounds like you need to come in for a consultation, then that's just what you need to do. But I will see you guys soon again on Wednesday night. Just meet me right back here at 9:30, and I will answer your questions. And in the meantime, over this weekend, I'll go in and manually type answers to some of the questions that I did not get to today, unfortunately. So hope you guys have a wonderful weekend, and I will see you very soon on Wednesday night. Okay.